Hi, and welcome once again to Beyond the Gavel. Today I'm joined by a practitioner whose name has become synonymous with tenacity in catastrophic injury litigation. Richard Edwards has built his formidable reputation not only as the founder of his own specialist practice, but also through 2 decades at the front line of some of the most complex and fiercely contested cases in the UK and abroad. His work spans the High Court and appellate litigation, cross-border disputes, and high-stakes challenges against major insurers, police forces, NHS bodies, and so on. He's achieved recognition that speaks for itself: awards for catastrophic injury practice, higher rights of audience, a deputy district judge appointment, and leadership roles, including with the Expert Witness Institute. Just as important is a track record for taking on clients whose cases others have declined. That's a mark of both courage and commitment to justice. So in this conversation, we're going to explore where serious litigation is heading, how specialist advocacy is evolving, and what it really takes to deliver outcomes for those whose lives have been turned upside down. So Richard, it's a pleasure to have you on the program today.
It's a pleasure to be with you, and thank you for the introduction. It's very kind.
You're very, very welcome. Now, give us a little bit your background, how you got into this in the first place.
I was educated in the local state comprehensive, where my son goes, same school. I was the first in my family to do a degree at university. I worked initially as a full-time printer's hand in a printing factory in the Liverpool area when I was doing my A levels. I then got into the University of Liverpool, where I studied law, whilst simultaneously holding down 3 or 4 part-time jobs at any given time. One of which was cleaning the university before lectures. Um, I got a first class degree. I came in the top 5% in my year. And then got a position with a local practice, Rex Makin and Co. Rex Makin, a very, very well-known lawyer in the Liverpool area, very well known nationally at the time. He's passed on now. I was his head of personal injury and clinical negligence there for about 10 years or so. And then off I went to Potteries Dolan, a catastrophic injury practice in Manchester. I worked for them for 10 years. Great work, great people. And then we were taken over by a firm called Hugh James, a much larger firm, 700 strong, based in South Wales, very well known, very well established firm. And then more recently, I've set up my own firm, I think, as you said, Richard Edwards and Co. And along the way, I've taken up the role of the Expert Witness Institute and the Deputy District Judge role, which I've taken on
I mean,
a lot.
it's a lesson to a lot of people. I mean, we hear a lot of griping at the moment about, how much it costs to go through uni. You and I both had to work our way through university in different ways, but we didn't grow up with silver spoons in our mouth. We had to get on with it and do it. And people say, oh, you're so lucky. But lucky is built on a background of tenacity and pushing things. Tenacity, which you have shown now when you're dealing with clients. Tell me, what drove you to set up on your own? And what differences have you found? What are the challenges that you didn't expect, maybe, that you've now found when going out on your own?
Uh, so setting up by myself wasn't an easy decision. It's a really difficult thing that you have to sit down and really think through. Um, I Throughout my career, I've been practicing for over 20 years now. I made a conscious decision to avoid working for really big corporate firms. Nothing against them. I just didn't feel that that would be the sort of environment that I would particularly enjoy. Corporate firms have corporate pressures, and they have to approach things in a particular way. That's just a fact of life. And so when I was working at Potter East Dolan, I didn't choose to work for a bigger firm. They acquired Potter East Dolan, and I gave it some time and just took the view that it wasn't the right option for me. And in this country, I don't know whether it's the same in other I suspect that it is in other jurisdictions, firms are becoming bigger. And the bigger firms are acquiring much more of the market share, as people say. And I took the view that I didn't really want to go to work with one of the other corporate firms for the same reasons. I anticipated that I wouldn't particularly find that enjoyable. And so you have various options: go to the bar, be a full-time judge, and all of those have particular challenges and different issues to take into account. And I took the view that setting up by myself was the right option for me. Um, and it's not an easy it's not an easy thing to do. There's a lot to take into account: professional indemnity insurance, setting up systems, setting up bank accounts, all of the compliance issues that go with that, and that takes you away from what you're enjoying doing. And I enjoy um, taking on difficult cases and working with clients, dealing with clients.
So
Um,
that's interesting, that compromise that you get there, because it's to do with relationships, isn't it? The bigger you get, and we all have different companies, and you put in systems, and with a big firm, there's a system that you follow. Systems are great to get things moving, but systems also are designed to keep things the same. They're designed to pull you into the system. And it takes a lot to break it. Whereas when you're in a smaller group, you can make that decision on your own to
mm,
change.
mm,
So there's a positive for having a system
yeah.
that, it's a cookie cutter. You just keep going it like a lot of personal injury does. But the disadvantage of that is that it's stuck
Mm,
in the system.
mm.
And there's a lot of data driven stuff now that is coming into the law. Um, what do you think? How has the profession adapted to this data driven defense, or work for the plaintiff? There's a lot more data, a lot more information appearing. How have you found that?
Um, so I, from the sort of work that I do, I catastrophic injury work, that sort of thing, some of it's stress work. You really do need to get yourself immersed in the records and in the material, analyzing things. Um, and there are no shortcuts to that. There are some people that think that you can throw your records into AI and you can get a summary of them. I take a different view. I think you've got to do a lot of the hard work yourself and continue to do that. Um, from the perspective of things like AI, if that's sort of what you're gearing towards, I think it has a role. And I think it's something that can help lawyers do a job, but there's still there's no there's no getting around the fact you've still got to be a lawyer. You've got to be able to work with AI. You've got to be able to harness the tools, the systems, the data, the expertise that is out there to try and help you do a job. But ultimately, it's all down to the same thing. It's looking after clients. It's understanding their needs. It's understanding their issues, and then developing a strategy, the best strategy, which accounts for your opponent's strategy. And a lot of that is knowing and understanding the law is a given as a lawyer. And that's a hard thing to do in and of itself, but it's a given. You have to then build on that beyond it, thinking about negotiation, thinking about behavioral psychology, and into those sorts of things comes the data and crunching the numbers and figuring out that the best approach to the most optimum strategy. That is where a lot of data comes in.
Well, I
And
think that's very true. We've got to treat it ethically and responsibly. To say it's not existing is just stupid. But it's got to be treated ethically and responsibility. And with young people coming through, we've got to make sure they do that and understand the ethics. I mean, some young people coming through go into our professions, and they don't realize their social media has followed them there.
yeah,
People can look up so many things. You only have to look at the news any day and said, you said this 20 years ago, and it comes back to bite you. So you've got to be very careful. So you then became a district judge as well, or associate with the district judge. How have you found sitting on the bench in the middle of, I know it's different type of cases, but sitting in the middle, how has that helped you in your practice? Do you think it has helped you by being able to have to sit back and listen to, the two sides discussing?
Yeah, without a shadow of a doubt. So there are two big impacts that have had most impactful things that have had on the way that I practice. First is being a solicitor advocate. In this jurisdiction, you have barristers who do the advocacy, you have solicitors who do the client work and the letter writing and so on. But you can also be a solicitor advocate where you do the advocacy. And going through that training taught me so much about how you present cases and how you gather evidence, which is ultimately what the court makes a decision upon. Um, I sit as a deputy district judge, so that means I'm fee paid. That means I have to sit a minimum of 30 days a year. Um, and doing that has really shaped how I present cases and how I think about cases. It's brought a degree of focus to the work that I do. It's enabled me to think more carefully about the strategies, think more carefully about the points that I want to take, what are good points, what are bad points. And once I've identified what I consider to be a good point, then how best to deploy that to get the most effective, optimum outcome for my client. And the judicial training here is really rigorous. The selection process is very, very difficult. It really does put you through the mill, and rightly so, so that they have really high caliber judges, and it's something that the country should be proud of, in my view. And then once you are established as a judge, there's a lot of training that you go through before you start sitting.
Judicial Studies Board and all that.
All of
So,
that.
from your point of view of sitting on the bench, what have you noticed then, looking down at two sides?
Mm.
What mistakes have you noticed coming up? That you say you shouldn't have done that, or if you were to go down and whisper in their ear, say, "What on earth do you think you're doing here?"
Ah,
Um, what things have you seen that are warning to other lawyers coming in front of a judge? Say, just don't do that, or be more explicit, or be simpler in your language. What things have you come up with that you have seen from the bench that would be helpful to people who are doing advocacy?
so the bar produces really high quality advocates, generally speaking, in this country. But they can only be as good as the instructions that they get. And
Mm,
a lot of them get instructed last minute. A lot of them don't have that opportunity to have a conference with the client until very late in the day. And so that, I suspect, when I see things that don't go particularly well, the explanation isn't so much that the advocate is a poor advocate, it's more that they haven't had the opportunity that they would like to make to carefully prepare what they want to do. And so to the extent that they can influence that, they should influence that. Um, Take the time to prepare, as much time as you can find to prepare, to focus on the issues, even if it's just a few bullet points that will allow you to focus your mind on what really matters
yeah.
on the paper. It doesn't really matter so much. And this is something that I've only very relatively recently learned through my own advocacy. The form of wording, the precise form of wording, is less important than the fundamental message that you want to get over.
Well,
Um,
isn't that true? You're always looking for the fundamental question.
yeah.
What is the question the court is being asked to decide? And there's a lot of waffle on the side that goes on. But if you can get to the focus, I mean, you're sitting as a judge, say, would you just get on? You know, here, give me, what I'm supposed to decide on, So what have you found from experts that you would say, watch those experts? What have you, having, been on that side and seen expert witnesses, what have you seen that maybe they need to think about, or you want to say through your expert witness institute thing to expert witnesses, said, hey, when you come up in front of me or come up in front of a court, think about these things, what would you say?
So it's a message for lawyers as well as experts, because ultimately they need the same thing. The most convincing, the best expert is the one that finds favor with the court. And the one that finds favor with the court is the person that the court can trust to be advising them on the particular issue that needs to be resolved. So the court has to decide the ultimate issue, and it's not the expert's job to solve that question. The expert's job is to help the court decide a particular issue that will enable the court to resolve the ultimate issue. And the expert is there to advise the court. And the court wants somebody, as I say, that they can trust. And that means they've got to be credible. They've got to be ready to accept the logic of a proposition that's put before them if it's logical, and not push against logical propositions. And they are the, if you do, that's a hallmark of somebody who's not there to advise and assist the court, but is there to argue the case for the person that is instructing them. And once an expert finds themselves in that territory, the judge who has credibility detectors alive all of the time, the judge is thinking, who's telling the truth, who's not, who's giving me something that I can believe. And the notion that an expert can get in, an expert, any witness, whether it's a lay witness or an expert witness, can get in and really mislead the court and trick the court into finding something. It's just not credible. The judge has read the papers. You've got advocates on both sides who are ready to pounce on you. And so, as a lawyer, I want an expert who is credible, who understands his duties to the court and acts in accordance with those duties. And my job as a lawyer is to try and make sure that, first of all, the expert understands that, and then to give him the evidence that I've built and then ask him for his view on it. And then and hope that that view or test that view, make sure that it is a rigorously formed view that can stand up to scrutiny, and then put it for the court and let the court decide.
Isn't that the truth? I mean, there's eminence and expertise, and sometimes eminence is equated to ego.
Yeah.
And expertise is equated to experience. So it's really the triumph of experience over ego, isn't it?
Yeah, completely.
And that's really what you say. You want credible people who've been there, done it, and can explain it and say the reason why.
Yeah.
And not because I said so.
Exactly.
Exactly. So
Exactly.
how has your job then, because you got that, and then you're on a director of the expert witness. How have you integrated that into your role with the Expert Witness Institute?
So I got involved with the EWI, the Expert Witness Institute, which is a really great organization. And if there are any expert witnesses who happen to listen to this, I encourage them to look at it and to do the training through it. I got involved after writing a very lengthy and detailed article on the duties of expert witnesses, and then I was very fortunate to be invited to be on the board. And I have really, really enjoyed being involved in it and helping it to grow as an organization. I feel very passionate actually about what they do, and the benefits that they bring to the proper administration of justice, which is part of the core mission. But to do that through enhancing expertise and standards in expert evidence. Expert witnesses have a very, very privileged role to offer opinion evidence in the court. And it's really important that that privilege is not abused, whether by the expert or by the lawyers who are introducing that evidence. And the EWI is a really fundamental part in ensuring that as far as they can, is adhered to. And from my own perspective, in my own practice, having spent a lot of time reading around the duties of expert witnesses and lecturing around it and doing more working on it going forward. In catastrophic injury work, you often have multiple experts in cases, and helping them understand their duties. I find it means that you get a lot more out of them. You get higher quality evidence. You're able to focus on the issues in the case and cut out all of the noise, all of the irrelevant stuff, and you've then got something that you can work with. It gives you a greater standing, a greater foundation upon which to build your case. And very recently we were talking about this at the Expert Witness Institute about the importance of trying to educate lawyers about their role, because the first responsibility for making sure that experts understand their duty falls to the lawyers. We're the ones, we're there, we should be telling them. And I have a concern that actually a lot of lawyers, instead of spending their time telling experts what their duties are, they spend their time thinking too much about trying to advance their client's case, which is important. Your duty is to act in the best interest of your client. But I say that to fulfill that duty, you need credible expert evidence that the court is going to find favor with. And that's what you need to be spending your time doing, not encouraging your expert to express a view that they might not be that might not be within their expertise, or they might not be comfortable with because you believe that's going to advance your client's case. I don't think that it does. What advances your client's case is having an expert opinion that is credible and reliable, and that means it's something that they're comfortable with expressing. It's as simple as
Yeah, there's
that.
always going to be that tension, isn't there? Your duty as a lawyer is to advocate for your client.
Yeah,
My duty as an expert witness is to advocate for the court.
yeah, yeah,
And there's always going to be that tension.
yeah,
And of course, then lawyers go and cherry pick. They go and look for somebody who's going to back them up.
yeah,
Just like you're reading, you're just, bringing your bias in, and you're
yeah,
finding somebody that's biased like what you are, if you see what I mean.
yeah, yeah, yeah.
So there is that confirmatory bias.
Yes.
And a judge is sitting there saying, well, I know, I mean, I hope I don't see it, but sometimes you can,
Yeah,
that there's confirmatory bias. You chose that expert because that expert is malleable.
yeah, 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 yeah. Completely.
And that's not a good idea.
Yeah,
Lastly, I'd like to talk to you. You take on, and you're known to take on cases that others don't.
yeah.
How do you decide early on about what cases you're going to take on, maybe that others haven't? And what's the difference between a justified perseverance with it and unrealistic advocacy? How do you balance that right up front when you're going to take on a case, say, that somebody else won't?
I judge each individual case on its own merits. The fact that another lawyer has turned it away doesn't mean it's a bad case. It might mean that the lawyer just doesn't have the particular appetite for that case. I have a different appetite for risk. I also have a strong belief in access to justice. I think it's important. Um, and I, one of the cases that I took on was for somebody who, and the case is reported, and these facts are public. The client was homeless, a heroin addict, a user of crack cocaine, paranoid schizophrenic, and she'd already lost a leg through intravenous drug use. And she fell from the window of a hostel. And you look at something like that with the facts and the background, simply taking instructions from somebody with that sort of background and those sorts of issues, who's homeless, is a challenge. Um, and thinking ahead is, how are you going to get this person to court? And is what they're going to say going to be credible? Will they be coherent? Will they be high on the day? And if they are, you got trouble because you can't prove the case without their evidence. Um, my view was that it was the case was a good one, and I took it on, and she turned up a trial, and it went to trial, a 6-day trial in Liverpool, and we won. But I was just ready, and in cases like that, and in other cases, I'm just ready to sort of plan and to make adjustments for the sorts of problems that they are going to give rise to. And in that case, we did have to plan. We issued the case in Manchester, but it was transferred to Liverpool for trial. That's where she was from. We asked the court to make adjustments to allowances, so she was given a clean start. She was effectively told your evidence will start at a particular time. Um, Adjustments were made for cross-examination. She had a support worker sat near her. And we took advice from a psychiatrist about the effects of a medication. And all of this was built into the plan for the trial so that she could participate and give her best evidence. And I'm confident that those adjustments meant that she felt comfortable about turning up, as comfortable as you can do to give evidence at a big trial. But she was able to properly participate. And the barristers involved were exemplary in how they did it. And as it happens, her evidence wasn't particularly reliable, but it didn't matter because we had other evidence that would prove the essential elements of the case. And that's where I came at it. I thought we could prove it with other aspects of the case.
Yeah, so you had the surrounding evidence, and I
Yeah.
think that's a good note to end it because that shows your advocacy and your belief, in the role of justice. Now it's a balance. There's justice for the plaintiff, there's justice for the defendant,
Yeah.
and there's a balance. But it's that advocacy, that knowledge base that you have such a wide range of that has allowed you to do this, and your other lives. I love the way that you worked hard to get where you are, that you've come from a background which wasn't privileged as such because you had to go out and work for a living. And so many of today's generation think they shouldn't have to do that. They should be, study a study and then I should be able to do what I want. No, you have to work for it. And you've shown that and done that. And you've also shown that same tenacity in looking after your clients. Richard, this has been a wonderful chat. And thank you so much for taking the time with us today and going through those points. I know that our audience would be fascinated to hear those bits from you. And so thank you very much for everything.
Thank you. It's been a pleasure.